This is Mr. Trammell, right?
Oh, I was just gonna call Mr. Trammell.
Ready? 26 CR 921 Trammell appearances.
Daniel Cohn on behalf of the people. Mr. Trammell is present.
Pro se.
On bond, pro se. Looks like last time we were in court, he was asking for extra time to potentially hire counsel.
I had, on April 6th, I indicated to you that you should apply for the public defender's office. Did you do that?
Yes, ma'am. No, I did not.
You didn't qualify?
In that time, a lot has transpired.
Okay.
Did you get the notice that I submitted into the case?
The letter?
Yes.
Did you get it, Mr. Cohen?
Try me to check real quick. Yes, I do see that.
So your, did you have first and foremost, I'll indicate to you that I am not an administrative law judge.
Okay.
All right. But it looks like based on what you were asking in here is that you're asking for restitution. That is not something that can be done out of this case.
Okay.
All right.
Okay.
And you're invoking a number of other,
Yes, I mean, given the nature that there's no injured party or no damage to property, I have a concern with an administrative court hearing
I'm not an
judicial matter.
administrative court.
You're not, this is not an administrative court?
No, this is part of the judicial branch. This is
an
not part
Article
of
3
the,
court?
excuse me?
This is an Article 3. We're in Article 3 court.
This is not an administrative court.
Are
This
we
is
in an
a
Article
part of
3
the-
court?
I mean,
That's just a simple question. I'm not trying to be difficult. I want to know what I'm walking into before
Your Honor,
I'm not trying to be difficult at all.
I would just ask
Given the
that,
nature of what's going on here, I need to know exactly what I'm,
so last time we were in court, this court agreed to continue, but said the court would expect to move forward on this date. At this point, the people would just ask that the court enter a not guilty plea on behalf of Mr. Trammell and set it for a disposition date. It sounds like Mr. Trammell has some philosophical beliefs about the system that don't exactly match with the facts of his situation, but that's neither here nor there.
you're citing the United States Constitution and we're governed here.
Absolutely.
I'm appointed by the state. So
Absolutely.
this is not a federal court. This is a state court. So no, this is not an Article 3 court. This is a state court. All right. This is not under the United States Constitution. I am not appointed. I wasn't nominated or confirmed by any federal body. This is a state court. So no, this is
Did you
not.
take an oath to the Constitution? And are these state rules repugnant to that oath? That's the only question I have.
Yes, there are state rules, and you are charged in this case with having a dangerous weapon, possessing a dangerous weapon, and having a large capacity magazine, which is prohibited. That's what you're charged with under the state law. So how do you want to move forward? You don't have an attorney. We're currently set for a appearance of counsel. So let's go ahead and set this for arraignment.
Z or Z.
All right.
Z or S.
Set for arraignment?
Yes, so at that point, or you can do that today if you'd like. Plead
No.
guilty, you can either reach an agreement or you can enter a not guilty plea. Do you want to enter a not guilty plea?
No, I do not.
What do you want to do today?
What he's saying is.
Set this for another arraignment. I need more time to figure out what it is.
So why don't we come back next Friday at 8:30, and at that time, it'll be set for arraignment. All right?
Friday?
Friday, the 29th.
Jump into today's courtroom chaos. You need to understand one thing. Confidence and competence are not the same thing. Because in today's lineup, we're watching 3 defendants walk into court absolutely convinced they've cracked some secret legal code the rest of society somehow missed. But there's just one problem: belief doesn't beat the law. And internet legal theories don't magically erase criminal charges. First, we've got a man facing serious weapons charges who immediately starts questioning whether the courtroom itself is even legitimate. Then, we move to a driver who seems fully committed to courtroom buzzwords he can't actually explain when pressed. And finally, a returning defendant doubles down on legal filings, accusations, appeals, and even threats to sue the judge. Personally, while somehow still refusing to deal with the actual charges sitting in front of him. What makes these cases fascinating isn't just the legal confusion, it's the collision between absolute certainty and courtroom reality. Watch closely, because judges usually give people room to speak, explain themselves, and even correct course. But when someone walks in convinced they already know more than the court, things can spiral fast. And trust me, the last hearing of this video, that one turns into a courtroom masterclass in patience, warnings, and consequences. So buckle up, because this gets awkward, dramatic, and at times genuinely unbelievable.
Last people who are in the docket. Thank you.
Front and center. Your Honor.
All right, so we have you here on a no valid operator's license. It looks like I'm still showing that it is expired. So what would you like to tell me today about the infraction?
Well, I'd like, Your Honor, if the court pleases, to certify the bond of subrogation, if you please.
Certify the bond of...
Yes, Your Honor.
Can you... Okay. One moment.
Yes.
So what would you like me to have certified?
The bond of subrogation.
What is the bond of subrogation?
You don't know?
Why don't you inform me? Is there a document that you have?
I can have the Justice Department send you one.
For what?
The bond of subrogation.
So, a subrogation agreement,
Subrogation is a bond.
correct?
That's a bond that you place on my name.
I have not placed any bond on your name.
Well, this municipality most likely has.
You are Alan Lee Waddell?
Correct.
Okay. And so there's...
See, when this court is, if you hammer me, all that money in that bond goes to the IMF.
there is no bond. There's an infraction with a fine amount. So if that's what you want to tell me today, we're here for a contested hearing. I haven't heard anything that...
Latches and curs. Are you familiar with the Constitution? Latches and curs, right? I motion to dismiss.
Okay, motion to dismiss on what grounds?
On grounds that you do not know what you're doing.
Right here, you can already see the first major disconnect happening. The judge is trying to clarify something simple. This is a criminal proceeding in state court, not some hidden administrative hearing. But notice what often happens in these situations rather than focusing on the actual allegations. The conversation immediately shifts toward questioning the legitimacy of the courtroom itself. And here's the thing viewers should pay attention to: whether someone agrees with the system or not. Courts generally still operate under established procedures. Judges aren't there to debate philosophical theories for hours, they're there to move cases forward. So when the defendant starts asking whether this is an Article 3 court, what he's really doing is stepping away from discussing the charges and into a legal argument that courts routinely reject. The bigger question becomes, is this strategy, confusion, or simply buying time? Let me know what you think, because this tension only escalates from here.
I'm sorry, Your Honor, you're supposed to know the law.
Okay.
Latches and curs.
All right. What legal authority do you have for your motion to dismiss beyond you don't think I know what I'm doing?
That will come from the Justice Department, Your Honor.
All right. Do you were stopped on February 25th, 2026?
According to Eric, the Kelso cop.
Okay.
Is he present?
Did
Is
you
Eric present?
Did you subpoena him?
I did, and
Did you file
I
proof of
also,
service of the subpoena?
excuse me?
Did you file proof of service of the subpoena?
I did. I filed a notice of liability.
That's not a service of proof of service.
It's a certified sign. It's a signed affidavit.
What signed
have that.
affidavit do you?
It's supposed to be in your possession.
I have it.
Okay. Have you read it?
Yes,
It's notarized.
Okay,
It's a notarized affidavit.
Indiana Bill of Rights. None of this is binding on this court.
Those are case law, Supreme Court case law. Standing.
Indiana Article 1 Bill of Rights is not case law.
Well, we're applying it to.
We are not applying Indiana Bill of Rights to Washington.
Your name will appear here.
All right. Mr. Waddell, I have in front of me the officer's narrative indicating that he stopped you on February 25th, 2026, driving a maroon Chrysler PT Cruiser on the northbound 1400 block of South Pacific Avenue. With its left and center brake light not functioning, initiated the traffic stop, identified himself verbally as Alan Waddell, stated he left his insurance back at his house and was unable to provide proof of insurance. The check of his DOL showed that it expired September 22nd, 2022. The photograph on Waddell's DOL record matched the driver, confirming his identity, and he issued the infraction. And you were warned about not having insurance and not having brake lights active. All right.
I informed the officer, Your Honor, at the time that there is no contract. The contract, the license, which is a contract, has expired almost 5 years ago.
Yet you were driving.
There is no contract.
You were driving on a public road. Okay. I'm going to find the infraction committed at the full amount of $564. You will have 60 days to either pay in full or set up a payment plan.
I will this, and
What was that?
I will have to recommend it. I must recuse you, Your
Okay,
Honor.
you can file that with the, you
At this
can
point in
make a
time.
motion, but I've made my ruling at this point.
I'm motioning for a mistrial, and I'm going to recuse you.
Okay, I'm
from this
denying
case.
those motions as they are not timely nor relevant at this point.
Under the
So your infraction
Constitution-
has been committed. If you would like to file motions to
You are
appeal
in direct
this,
violation
go
of the
ahead.
constitutional rights, Your Honor.
All right,
You
Mr.
are
Waddell, that'll
committing-
be all for today. All right.